Hey, it's Shamika T. Askew with the Law Office of Shamika T. Askew, located in Brandon, Florida, and also licensed to practice in the state of Michigan. So this is my part 2 of This is the Court's Bible. We are talking about the best interest factors. Again, this is Florida best interest factors. I want to focus on one of the factors that talks about the geographical location of where the parties actually reside. So a lot of times parents don't realize that the distance between them can make a really big difference in how much time sharing they may get. Now, in Florida, technically speaking, the statute allows you to relocate within 50 miles of your current residence. So people are like, oh yeah, okay, I'm within 50 miles. But let's think about this. If you live in Florida, you know that 50 miles can take a long time, over an hour easily, without traffic. So having said that, I had a recent trial where the parties lived about 23 miles away from one another. Now, on its face, that doesn't seem like that's pretty far. So a 50-50 time sharing plan seems pretty feasible, right? Well, not so much if you have a judge that really takes this factor into consideration, where they don't want the child going from home to home or home to school that's like 45 minutes to an hour away. So they look at how far your house is from the other parent's house, how far your house is from the actual school where the child is currently registered, if the child is actually in school. And one thing that I told this client not to do, and you guys find out the hard way when y'all don't listen to me, is I said, do not bring up that you want to change this child's school or your child's school because of convenience. I said you don't want to go into court looking very selfish, because they are called best interest factors, and we're talking about the best interest of the child, not what's convenient for the parent. So guess what? When I said that to the client said, I want to be optimistic. You never know, the judge may consider it. I said, I wouldn't advise it. We go in there, they bring up, hey, I want my child to change this school. Why do you want the child to change this school? Oh, because this distance from my house. Guess what the court said? Oh, well, this is not about convenience for you, parent. This is about what's best for your child. So don't do it. If it has anything to do with what's convenient for you, the judge doesn't care. Leave it out. That's my recommendation. But, sometimes you all have to hear the judge tell you that. And I say that because I never want my clients going into court looking like the unreasonable parent or looking like the selfish parent. Always put on the cap of, is this best for my child? And guess what? Having a lawyer like me, I will tell you. If you haven't found out by now watching my videos that I am pretty direct and I'm going to tell you, yeah, you're being unreasonable, or no, that doesn't make sense, or you look selfish, I'm that lawyer. Sometimes the lawyers, my clients don't like me in the process. But in the end, they know that, yeah, that's what Shamika tried to tell me. So I say that because I mean well. I just want you guys to be prepared, especially for you guys who just have to know the outcomes. I do my best to try to tell you what I think may happen. No lawyer can guarantee any result, but I do know that you never want to go into court making it seem like it's about you, because you're already losing the judge right there. Remember, their attention span is not that great. You want to keep them focused on what's important. So keep it about the kids. This best interest factor is only focused on the distance. So it's better if you guys can stay as close as possible, so that way you can effectuate a 50-50 time sharing plan if that is best for your child. I don't know, can't say. Hope that helps. Again, Shamika T. Askew with the Law Office of Shamika T. Askew, located in Brandon, Florida, and also licensed in the state of Michigan.